Inside America's Boardrooms, the informational show for board members and corporate secretaries. Brought to you with knowledge partners NASDAQ, the Center for Audit Quality, and PwC. Along with content contributors Equilar, Meridian Compensation Partners, Wilson Sonsini, Goodrich, and Rosati, R.R. Donnelly, and the Society of Corporate Secretaries and Governance Professionals.
Welcome to this edition of Inside America's Boardrooms. I'm TK Kerstetter, the CEO of Boardroom Resources, and it's my pleasure to welcome you to the show. We're filming again from the studios here at the NASDAQ Entrepreneurial Center, which is a nonprofit organization that works with entrepreneurs and provides mentoring and networking and training, all at no cost to the entrepreneurs. Very cool setup, and we thank them for lending their studios for this. And today, it's my pleasure to welcome Katherine Henderson, who is a partner with Wilson Sonsini, Goodrich, and Rosati, which also happens to be, your firm happens to be a partner with the Entrepreneurial Center, which is no surprise knowing how you guys have worked with startups and companies like that. Today we're going to be talking about understanding your liability as a corporate director. And my first question for you is, we obviously have seen big transitions when we had the financial crisis, Dodd-Frank came along, and my question to you, has there been any changes either due to Dodd-Frank being introduced or changes in the Delaware Court of Chancery that in any way change the director's liability about serving on a public company?
Yeah, I think the schemes for liability are largely the same, but because of all of these regulations and new case law, I think directors are finding themselves under much more scrutiny these days. And as a result, they're much more likely to end up in litigation or being investigated by a governmental agency. So I think directors have to be much more careful and much more vigilant because of all that attention they're receiving. You know, I think a big area that courts are focused on and government agencies are focused on is where red flags appear to the board. The board really needs to chase those down and make sure that there's no misconduct going on, and that's really the board's oversight role. But you know, I think it's still the case, you know, under Delaware law, where most of our corporations are incorporated, that the business judgment rule is still alive and well. Right? So you have a scheme where courts are not supposed to be substituting their judgment for the director's business judgment. But I think there's two important caveats to that, and the courts are really focused on process and conflicts. So courts will defer to independent directors where they follow a thorough process, and that's really important. In cases where the directors have conflicts or they're interested in a particular decision or they don't follow a thorough process, I think that's where directors are going to find themselves in a bit of trouble. So generally keeping that in mind, you know, I think is really important and will go a long way. I think, you know, an interesting trend that we've seen in the Delaware courts these days is in M&A litigation. You know, it's widely known that, you know, over 90% of public deals get sued on these days. So if you're a director on a public company and you approve a transaction, you're going to be in litigation, right? But we've seen a sort of evolution there. And, you know, Vice Chancellor Laster gave a speech recently where he talked about 3 new cases that came out of the Delaware Supreme Court over the past year. And we've seen an evolution you know, away from the old regime of Revlon and Unical, where there was more scrutiny applied to the director's decisions in these contexts, to more deference and sort of a return to the business judgment rule. And the latest case in KKR, they actually said that you can get back to business judgment rule where there's a fully informed shareholder vote. And so I think we're going to see less scrutiny applied to those decisions in the coming years. But the important caveat there is a fully informed decision. I think that's another trend that directors want to be really careful and focused on, is making sure that shareholders have all the information when they're being asked to make, you know, a vote on something, make a decision. And directors want to get involved and make sure that the disclosures they're putting out in proxies are accurate and fulsome.
And remember, duty of loyalty, duty of care, and I think what you've all described there is good faith. Yes. As well, that you hear being brought up by the Delaware courts more and more. Are they acting in good faith? Are they involved in the situation? So I think that's great advice. Now, an offshoot of that liability is the D&O policy, and everybody gets this sort of sense of security that okay, we have a D&O policy. If someone joins the board, their first question is, do we have D&O coverage? And somebody says yes, and the director feels very good. It's not that simple, though. When
No.
someone takes the seat in the boardroom, there's certain questions that they should be asking, particularly when you look at something that is called Side A. So, A, could you quickly explain Side A? And then secondly, what questions should a new director or someone going on a board be asking relative to their policy?
Sure. So I think you're entirely correct that not all policies are created the same, so you really want to be digging in as a director. To take a step back and give a general overview, most D&O policies have 3 types of coverage included in them, and we refer to them as Side A, Side B, and Side C. Side A is for the directors and officers themselves in situations where the company doesn't indemnify. You know, that's going to be most likely your bankruptcy situation where the company doesn't have the funds. Side B is where the company indemnifies and the company gets coverage from the D&O policy. Side C is coverage for the company itself, and it's limited to what we refer to as securities claims. So you have all 3 layers of those coverage in one policy. Most likely where you're going to be getting coverage in a primary policy is on your Side B, where the company is indemnifying and then the directors and officers look to the company first, the company looks to the policy. A separate Side A policy just is for the directors and officers. And I've actually seen these becoming more and more popular. It's the insurance for the insurance. It's not likely to be implicated in most cases, but it's where the directors and officers are really going to need insurance, right? Where the company is not available to indemnify. They'll be able to look to these separate policies. And most of them are referred to as DIC, which is a difference in conditions, and so they drop down if coverage is not available, indemnification is not available. I've seen companies getting more and more of that level of coverage, multiple Side A policies stacked on top of each other. It's a risk analysis. What type of coverage do you want? Coverage for the company, coverage for the D's and O's. But that Side A is what's really important for the individuals, and they really need to be focused on it and careful. I think generally when you talk about insurance, a lot of folks think all policies are the same, and they're really not. The important parts of the policy are not just the limits or the types of coverage. It's what are the exclusions? What are the policy provisions? And you don't want to just rely upon a broker summary, which gives you sort of a general lay of the land, because the policy language makes a big difference. So I do a lot of policy reviews for outside directors, and I'll go through it, and you want to make sure there's a ton of exclusions in D&O insurance policies, but not all exclusions are created the same, right? So you can negotiate with carriers and try to get those exclusions to be as limited as possible. One exclusion which I find that directors are not often aware of is that, and it's in every policy, and it's an insured versus insured exclusion. So if you have a claim by one insured against another, no coverage under the policy. And that can include a former director or officer who brings a claim against the company or the board, no coverage under the policy. And a lot of times I find that our clients are surprised about that if a claim like that is filed. But you can carve back from that exclusion, and a lot of times the carriers will work with you. I've seen actually an increasing rise in what's referred to as an entity versus insured exclusion. So they replace the insured versus insured with an entity versus insured, and that's much more limited. It only applies when the company brings a claim against one of the individuals. And that's obviously much better, right? So you want to be looking for that type of thing, and that's why I think it's important to get someone to review your policy. Not just a summary, the actual language of the policy, so you know what all the bells and whistles are, and you're getting the most complete coverage possible.
So, Katherine, in the time that we have left, what steps or things would you recommend to a director to help mitigate any of their liability looking into the future?
So we talked about D&O, but the other thing you want to look for is an indemnification agreement with the company. You don't want to just rely upon Delaware law or the charter or the bylaws, because there's a lot of bells and whistles in indemnification agreements as well. They're quite lengthy. The most important thing you want to focus on in an indemnification agreement is advancement. You want to make sure you're getting your fees advanced before the litigation is resolved. And that's what you're going to get in an indemnification agreement. Another important thing I like to focus on for particularly outside directors is, does the company have the ability to assume the defense? Do you want, as an individual, the ability to hire your own lawyer and to monitor that lawyer's work? And I think in most cases you will want that. So you want someone looking at your agreement to see how it's going to be triggered and how it's going to play out if a claim is actually filed. Second thing I think directors really need to focus on is board minutes. I think we've seen a lot of cases over the years where my partner, Bill Chandler, wrote a decision in Disney about this, where the board minutes are not as fulsome as they should be and perhaps talking about the process that the board went through. And oftentimes that means you have to stay in litigation longer, whereas if the board minutes had been more detailed and really explained what the process was, you can get out of litigation earlier or not even end up in litigation. I think we're seeing a lot of 220 demands being filed by shareholders. 220 is a provision of the Delaware statute which allows shareholders to make books and records demands. And we're seeing a lot more of those. And when shareholders get board minutes, which shows a really good process, I think they're less likely to file the litigation down the road. Last thing I think that directors really need to focus on is getting really good advisors. Under Delaware law, they're entitled to rely upon those advisors. But we've seen cases now where courts are really talking about the obligation of the board to monitor those advisors and vet those advisors for conflicts. There's been a rise in aiding and abetting liability of advisors in the Delaware courts. And the Delaware Supreme Court just came out with Rural Metro yesterday. And part of the analysis there is, did the board really oversee the advisors? Did the board vet any conflicts that they had? So I think the board's going to want to make sure they're getting much more involved and not just taking a back seat and letting the advisors do their work, but really staying involved and monitoring.
Well, Katherine, it is great advice, and hopefully it will help people that are worried about their liability and what has changed. And I want to thank you for taking the time to join us today at this great facility of the NASDAQ Entrepreneurial Center. So thanks for joining us. And that will conclude this edition of Inside America's Boardrooms. We hope you enjoyed the show. We'll be back again next week when we take a look at another critical topic that'll help you be a better board member or committee member. So we'll see you then.
Join us again next week for Inside America's Boardrooms. Brought to you with Knowledge Partners, NASDAQ, the Center for Audit Quality, and PwC. Along with content contributors Equilar, Meridian Compensation Partners, Wilson Sonsini, Goodrich, and Rosati, R.R. Donnelly, and the Society of Corporate Secretaries and Governance Professionals.